The Court will use the criteria it has identified in earlier cases and examine whether there is compelling evidence that Kenya's claim to a maritime boundary at the parallel of latitude was maintained consistently and consequently called for a response from Somalia. It will then consider whether there is compelling evidence that Somalia clearly and consistently accepted the boundary claimed by Kenya. In this respect, the parties present arguments regarding the proclamations by the President of the Republic of Kenya dated 28 February 1979 and 9 June 2005, to which I shall refer as the 1979 proclamation and the 2005 proclamation, as well as Kenya's 2009 submissions to the CLCS and their respective domestic laws. They also refer to other conduct of the parties in the period between 1979 and 2014. The Court examines these arguments in turn. The 1979 proclamation was concerned with Kenya's exclusive economic zone. It stated that, I quote, "The exclusive economic zone of Kenya shall, in respect of its northern territorial waters boundary with Somalia, be on latitude 1 degree 38 minutes south." The Court notes, however, that Section 2, subsection 4 of Kenya's Territorial Waters Act of 1972, which remained in force when the 1979 proclamation was issued, stated that, I quote, "On the coastline adjacent to neighboring states, the breadth of the territorial sea shall extend to a median line," end of quote. The Court thus observes that Kenya was not consistently claiming a maritime boundary with Somalia at the parallel of latitude in all maritime areas. On 25 August 1989, shortly after ratifying UNCLOS, Kenya adopted the Maritime Zones Act, which is still in force. In respect of the delimitation of the territorial sea, Section 3, subsection 4 of the 1979 Maritime Zones Act provides, I quote, "On the coastline adjacent to neighboring states, the breadth of the territorial waters shall extend to a line every point of which is equidistant from the nearest points on the baselines from which the breadth of the territorial waters of each of the respective states is measured," end of quote. As regards the delimitation of the exclusive economic zone, Section 4, subsection 4 of the Act provides that, I quote, "The northern boundary of the exclusive economic zone with Somalia shall be delimited by notice in the Gazette by the Minister pursuant to an agreement between Kenya and Somalia on the basis of international law," end quote. The Court considers that Kenya's position is at odds with the text of the 1979 Maritime Zones Act, which refers neither to the 1979 proclamation nor to a boundary at the latitude for either the territorial sea or the exclusive economic zone. In respect of the exclusive economic zone, the text of Section 4, subsection 4 of the 1989 Maritime Zones Act provides that the northern boundary of the exclusive economic zone with Somalia shall be delimited pursuant to an agreement between Kenya and Somalia. These words stand in contrast to the text of Section 4, subsection 3, which provides that the southern boundary with Tanzania shall be on an easterly latitude, employing similar terms to those found in the 1979 proclamation. Section 4, subsection 4, thus implies that, unlike the situation of the boundary between Kenya and Tanzania, Kenya considered in 1989 that there was no agreement with Somalia on their maritime boundary. The Act refers instead to an agreement to be concluded and published in the future. It was therefore reasonable for Somalia to understand Kenya's position to be that an agreement was to be negotiated and concluded at a later date. Kenya's 2005 proclamation replaced the 1979 proclamation while generally reaffirming its terms. With regard to the exclusive economic zone, the 2005 proclamation modified the parallel of latitude claimed as the boundary with Somalia. The proclamation included two schedules, one of which implying that for Kenya, the boundary of its territorial sea with Somalia also followed the same parallel of latitude. Kenya has also drawn the Court's attention to two notes verbal from the Ministry of Foreign Affairs of Kenya to the Ministry of Foreign Affairs of the Transitional Federal Government of Somalia, dated 26 September 2007 and 4 July 2008. In the note verbal of 26 September 2007, which concerned the process of delineation of the outer limits of its continental shelf, Kenya claimed that the maritime boundaries between the two countries have been drawn using the parallel of latitude in accordance with Article 7483 of the UNCLOS, and requested Somalia to confirm, I quote, that the transitional federal government agrees with the way the maritime boundaries between the two countries are drawn as deposited with the United Nations by the government of the Republic of Kenya, end quote. The aide-memoire attached to the note verbale stated that the boundaries between our two countries have not been defined. In the note verbale of 4 July 2008, Kenya asked the government of Somalia, I quote, to state its position to the government of the Republic of Kenya that the transitional federal government of Somalia agrees with the maritime boundaries between the two countries as drawn and deposited with the United Nations by the government of the Republic of Kenya, end quote. The court observes that the notes verbale did not characterize the maritime boundary claimed by Kenya as an agreed boundary, but rather invited Somalia to confirm its agreement. It has not been shown that Somalia provided such confirmation. The court then examines Kenya's 2009 submission to the CLCS, observing that the list of coordinates and the maps included by Kenya in its submission show a single maritime boundary with Somalia at a parallel of latitude extending beyond 200 nautical miles to the claimed outer limit of its continental shelf. The court notes that Kenya's 2009 submission to the CLCS was made for the purpose of delineating the outer limits of its continental shelf, which is a process distinct from the delimitation of continental shelf. In this regard, Kenya's submission indicates that, I quote, Kenya has overlapping maritime claims with the adjacent coastal states of Somalia to the north and with the United Republic of Tanzania to the south, end of quote, and mentions that Kenya and Somalia had signed in 2009 a Memorandum of Understanding, which I shall refer to as the MOU, agreeing that they would not object to each other's submissions to the CLCS. As previously noted by the court in the 2017 judgment, the terms of the MOU suggest that the two states recognize that they have a maritime dispute that is unresolved, and identify the area under dispute as that in which the claims of the two parties to the continental shelf overlap, without differentiating between the shelf within and beyond 200 nautical miles. They also suggest that the parties intended to acknowledge the usual course that the limitation would take, namely engaging in negotiations with a view to reaching agreement. In this connection, the MOU provides that, I quote, the delimitation of maritime boundaries in the areas under dispute shall be agreed between the two coastal states on the basis of international law, end of quote. The court observes that Kenya's 2009 submission to the CLCS also alludes to the lack of agreement between the parties on the maritime boundary in the exclusive economic zone. In respect of the boundary with Tanzania, the submission explains that an agreement is in place between Kenya and Tanzania concerning the delimitation of maritime boundaries. However, in respect of the boundary with Somalia, the submission states that the exclusive economic zone boundary, I quote, shall be delimited by notice in the Gazette by the minister pursuant to an agreement between Kenya and Somalia on the basis of international law, end of quote, thus employing the same terms as Section 4, Subsection 4 of the 1989 Maritime Zones Act. The submission also notes the existence of an unsettled boundary line between Kenya and Somalia. From these terms, it was reasonable for Somalia to maintain its understanding that an agreement had yet to be negotiated and concluded.